count them, two suppressions have been filed in the Delphi murders case. The first confession wants to kick out confessions of the actual crime made by Richard Allen while he was in custody at the Indiana Department of Corrections, while he's drinking toilet water, acting crazy, getting tased. The second suppression is the attorney want to kick out talk of this bullet. Now, I'm not exactly sure what the angle of that one, but it has been filed, so there's two suppressions. Now, in a normal case, when a suppression is filed, the judge, the prosecutor, the defense attorney get together and they say, hey, what witnesses do you need? Let's get them on here. Let's do this way before the jury trial so we can figure this stuff out. And if the judge will say, you know what, listen, I might be wrong, and if I'm wrong, you guys can appeal me, that's why we'll do it way ahead of time. Everyone knows who is watching this Delphi case, this case is nothing but normal. So now, 3 weeks until a jury trial is starting, probably the biggest case in Indiana history, defense has filed two suppressions, trying to kick out all sorts of stuff. Now, let's walk through this. Now, I'm not going to talk about the actual suppression contents. It's a different video. We're going to talk about just kind of what normally happens and what's going to happen with this case. It's really important to understand the judge does not have to set a hearing on these motions to suppress. There's no rule or requirement the judge has to say, hold up, I'm going to set a hearing. What can I do for you guys? That's not a rule. But normally, judges do, in fact, do these things way ahead of a jury trial. And so you'll see even the rules put forth by the Indiana Supreme Court, the Indiana criminal rules. These are the rules the courts have to follow for criminal cases. They say it's encouraged that defense files a motion to suppress well ahead of time before a jury trial. And the reason why is very important, kind of what I talked about. There's going to be witnesses that need to come for the suppression that may not need to come for the trial. There's going to be things that come in. Evidence is going to be heard that may or may not come in at trial. That sounds crazy, right? But the rules of evidence are a little bit different for a suppression than a trial. So some things that may not get in at trial would be allowed at a suppression. And we want to have time to get this right. Now, the reason why most courts allow a hearing before the jury trial, even though it's not required, is because the courts don't want to have to get a jury, have that jury just sitting there doing nothing, twiddling their thumbs. Jury's just getting more and more mad. I'm off work. I'm supposed to take care of my granddad. Supposed to be putting up a barn. Supposed to be driving kids down a bus. Who knows? People may want to be on the jury, but no one wants to be waiting on a jury. And if the jury's just sitting there waiting while they're doing this at the jury trial, it's just wasting a lot of time. And it shows, some judges say, Mark, it's disrespectful to the jurors to make them just wait when you could have done this before the jury trial. And I've gotten yelled at plenty by doing suppressions mid-trial. And I usually do it because I want to ambush the prosecutor and the state because it's fun that way. It usually helps my case by making these prosecutors think fast on their feet. Sometimes they get it wrong. Sometimes they get it right. Sometimes judges are so unhappy with the suppression middle of the trial, I think they may give the prosecutors a little bit more leg room than normally would give. But the reality is, judges don't like it, and it's frowned upon to do it at trial. Now, the defense attorney is allowed to do a suppression at trial, and the judge theoretically could say no. If they say no to the suppression, that creates all sorts of other issues. I've never seen that actually happen. If a defense attorney stands up and says, Judge, I have a possible issue of suppression. I'd like to ask some questions of this witness. What I have seen with my own two eyes doing this for almost 20 years is judge saying, okay, ladies and gentlemen of the jury, we're going to have you get up. We're going to get out of here real quick. And we're going to talk about some matters that you don't have to be part of. So go back and have a little snack. Go to the bathroom break. Don't talk about the case. And then once they're out of there, the judge is like, really? We're doing the suppression now? And the suppression hearing goes. And, in this particular case, trying to kick out confessions. They're going to try to show that confessions were not voluntary. And so the state of Indiana has to show they were voluntary. They were not part of some undue influence or whatever. It's going to make a lot of work in the middle of the trial. The defense team didn't have to file motions ahead of time. Some would even say perhaps they were being polite by letting the state of Indiana know, hey, this is going to be an issue before trial. They could have sprung it at trial. But that would have created all sorts of scheduling chaos. Now, regardless if the judge does grant a hearing before the trial and the judge says, no, we're going to allow that stuff in, the defense team still has to object at the trial. They can't rest on their laurels and say, well, we did a whole thing beforehand. You have to object at the time. And that's a standard. A person who wants to keep out evidence has to object before that evidence is admitted. That's the legal standard. So that's why suppressions are allowed at trial, but they're most often done way ahead of time. So I'm trying to think of an analogy of, doing a suppression at trial. And the best thing I can think of, of how pain in the butt it is for the trial, for the judge, for the jurors, for the defense team, for the prosecutor, is, I'm 43 years old. My mom is 75. I am frantically trying to nail down all the family recipes that she makes because they taste good. I want those for my children, my children's children. As you can tell, I like to eat. My favorite thing in this world is lemon meringue pie. This past Christmas, I asked my mom, hey mom, I want lemon meringue pie. She said, Mark, go buy all the ingredients. Go take care of it. You know what you need. I went out there and I bought everything. I bought everything I thought we needed. I looked at the back of the recipe, in the box, things I remember from my childhood. Christmas Eve, I'm sitting there with my mom at 8 p.m. at night. Kids are in bed. Mom, let's make this recipe. I'm going to write stuff down, how you do it, how you mix it, how you do everything. And my mom looks at the ingredients, and it's Christmas Eve. She looks at the ingredients. Hey, Mark, you forgot the cream of tartar. Cream of tartar? What? This is a lemon meringue pie. We're not making fish and chips. She shakes her head. No, Mark. Cream of tartar goes in the egg whites. Makes them taste good, look fluffy. I need you to go get it. We can't do nothing. It's 8 p.m. I'm tired. I want to make this pie. I want to be done with this. I want to learn. But no, I'm going out at 8 p.m. to the grocery store to go buy cream of tartar for these pies. It's inconvenient. I wish they would have told me ahead of time. I wish I would have asked for a list. So inconvenient. I was already exhausted. I want to make pies, not shopping at 8 p.m. on Christmas Eve. That feeling is exactly what it's like to do a suppression in the middle of trial. And the judge is not going to appreciate it. The state's not going to appreciate it. So why did the defense do it? Well, I have a few ideas. I'm not sidekick though. I think this is a great divide and conquer strategy by the defense. State of Indiana has to get ready for jury trial less than 3 weeks away. They file these 2 motion to suppress. Now, instead of working on a single jury trial, State of Indiana has to work on a suppression for the actual confessions and a suppression of this bullet talk. And now where there is 1 issue, there's now 3. And so they're dividing this case and making more work for the state. Now the defense is making more work for themselves, but I think it's a strategy by the defense to make more work for the state. But also, this suppression seemed pretty valid. We shouldn't let people make confessions when they're crazy. We shouldn't. We shouldn't allow confessions in when someone says, I want an attorney. Those are fundamental things we should not do. So I agree with the defense, what they're doing. It just may not be as well received as perhaps they might think or would normally be received. So I do think this might be a strategy situation by the defense to make more work for the prosecutor, to have them scrambling and not focusing on the trial, but focusing on other issues as well. And I think the state did it to the defense as well with the filing of the contempt. We're going to make the defense work on other things in the jury trial. And I think they're a tit for tat type situation. I don't really feel too bad for the state, though. They brought the charges. They brought it with this evidence. They should know what they're doing. The defense is trying to defend a possibly innocent man going to jail the rest of his life. And if he's found guilty, he will go to jail the rest of his life. I want to focus back on the judge here. I do feel bad for her. This is just like throwing papers in the air. It's going to make absolute chaos for her. She has to figure out, am I going to do a suppression hearing within 3 weeks? Can we do a suppression hearing in 3 weeks? Will a suppression hearing take 3 weeks to do in this case? There's a 136-page Frank memo that they're going to want to talk about at the suppression hearing. So I don't envy her. I don't envy her calendar. This sounds crazy from all angles, and I could not even imagine being in the shoes of this defense team trying to do a suppression on 2 separate issues within 3 weeks of a trial where the entire world is watching. It seems really stressful, and wish them the best. So, if you watched this far and this long, like and subscribe to my channel. Please leave a comment. I will do my best to respond to every single comment, though that's not always possible. Some of the comments don't make sense, but a lot of them are really smart. And I really appreciate the comments. I will try to respond to all of them. Most importantly, do what Richard Allen did not and plead the 5th.